Welcome, everyone, to the inaugural episode of the Williams Mullen Manufacturing Edge, a video series addressing key topics affecting manufacturers. My name is David Burton, and I'm a partner here at Williams Mullen in the Labor and Employment section. I'm joined by my colleague, Scott Terrell, an associate in the section. Here at Williams Mullen, we work with many manufacturing clients to deal with issues that they have to address with their workforce and issues that come up with their workforce employees. This has been especially true during the COVID-19 pandemic, and it seems like every day things change for manufacturers. Well, Scott, how are you doing today?
I'm doing well. Thanks, David. So today we're going to discuss several hot topics, including marijuana legalization, discrimination in the workplace, and COVID-19. But let's first start with wage and hour law, and in particular, the role of classifying workers as independent contractors. So could you talk to us, David, about the standard for determining whether a worker is an independent contractor or an employee, and what are the implications of that?
Well, I mean, the standard for addressing whether an individual is an independent contractor or an employee has been around for a long time. Generally, what we see is most federal and state agencies and states apply the IRS 10-factor test to determine whether someone is actually an employee versus an independent contractor. However, the federal government and many state governments have begun to feel that many employers, including those employers in the manufacturing industry, have engaged in widespread practices of mischaracterization of their employees and in calling them independent contractors. And of course, the benefit that an employer would see if it did so would be some tax issues and benefit issues. And it's a slippery slope. What has happened and what we're seeing across the country is both the federal government and states taking efforts and steps to try and keep employers from mischaracterizing individuals as independent contractors. And those provisions we're seeing in many different ways. Currently, there is a statute in Congress to amend the National Labor Relations Act, which many manufacturing employers are familiar with because many manufacturing employers have labor unions. But if this statute is passed, it's called the PRO Act, Protecting the Right to Organize, it would create a presumption that any individual who provides work to an employer is an employee and not an independent contractor, unless by a heavy weight of evidence, that employer can actually establish that the individual is an independent contractor. So if you have individuals in your manufacturing plant who are working alongside individuals you have classified as employees, there's a good chance if they're performing the same duties, they will be considered to be employees, not independent contractors. And in fact, that PRO statute goes one step further and almost eviscerates the ability to talk about somebody coming from a temp agency, not being your employee. You're going to be considered to be the employer of those individuals, at least as a joint employer. Many states have also established or adopted statutes that also try to do the same thing. Virginia, if you're a Virginia manufacturer, last year, Virginia adopted a statute that provides that an individual, if they perform services for an employer for remuneration, they'll be considered to be an employee unless the employer can establish through the use of the IRS test that they are truly an independent contractor. And that statute actually has not only, if you misclassify somebody, you're going to be required to go back and pay them properly, provide benefits to them, but there are also civil penalties for improper classification.
Yeah, and that's one thing in reference to penalties. I think it's important that that manufacturers are aware that oftentimes these statutes, like the Virginia one, carry provisions for attorney's fees. So if you don't get it right the first time, you could be paying fees to your attorney and the attorneys on the other side.
Every employer loves that
Yes.
scenario.
So another hot button issue right now is, of course, marijuana and marijuana legalization. Right now, most states have either to some extent decriminalized or just made marijuana completely legal. Could you talk about the distinction between medical marijuana and recreational use marijuana in terms of these efforts to legalize marijuana?
Well, what we've seen in a lot of states that have uh, adopted or decriminalized marijuana is there will be a distinction for employers if employers choose to test and look at whether individuals are using marijuana. And that distinction is if someone has uh, a doctor's prescription for the use of medical marijuana or CBD oil, those types of things, then generally under the Americans with Disabilities Act and corresponding state statutes, the employer there will have to look at, you know, can I reasonably accommodate this individual's use of prescribed marijuana or CBD oil, uh, or those or THC, those types of things. And generally, what it's coming down to is yes, the employer will have to do so. Uh, Now, there will be a difference, and we'll talk about that in a minute, perhaps with safety sensitive positions. But when it comes to recreational use, most states are still, most states still look at recreational use of marijuana as something that an employer can say, no, if you're testing positive because you're engaged in recreational use of marijuana, that can be a job disqualifier, either being hired or if you were to come up on a random test or a post-accident test at work, that individual doesn't necessarily, is not necessarily guaranteed to continue employment or be hired. Now, safety sensitive positions are a little bit different. A lot of employers deal with, especially in manufacturing, those employees who are in safety sensitive positions. And there's a myriad of different positions that could be, but as one very easy one is think about your warehouse workers, people who drive forklifts. That's a safety sensitive position. To the extent that someone has been prescribed medical marijuana and they are using it and that impairs their ability to perform their job, drive the forklift safely, operate it safely, the employer in that circumstance isn't necessarily going to have to reasonably accommodate the employee's use of medical marijuana. There may have to be a more engaged dialogue about what is another reasonable accommodation.
Yes, and another interesting wrinkle I think is the state versus federal, because marijuana is still not legal at the federal level, and you don't want to lose a federal contract because you are allowing employees to smoke marijuana. It kind of reminds me of when I was working for the federal government in California when marijuana was expansively legal, and I remember my boss said to me, Scott, it may be legal to smoke marijuana in California, but it's not legal for you to smoke marijuana in California. So it's always important to be aware of those distinctions. Now, let's also talk about workplace discrimination. So we know that Title VII protects against discrimination in the workplace. Are there any recent expansions that the manufacturer should be aware of?
Well, of course, manufacturers are certainly cognizant and know that last year the United States Supreme Court issued several decisions dealing with, is someone who is transgender, is someone who has a sexual orientation that is beyond what you would normally think, are those individuals protected under Title VII for purposes of sex discrimination. And the United States Supreme Court held, of course, that yes, they are, that the language of Title VII is broad enough to encompass those types of distinctions. So it is now important, and employers have to be cognizant of that fact that you cannot discriminate against an individual because of their sexual orientation, whatever it may be. You have to treat that individual as you would treat all other employees. We're also seeing that move in a lot of states. Now that the United States Supreme Court has issued its decisions, you see a lot of states going back and amending their human rights acts to add that language. And in fact, that happened in Virginia, in the Virginia Values Act, which amended the Virginia Human Rights Act last year. The definition of sex discrimination was expanded to cover those very situations.
Yeah, that's really, really interesting to see how the country is moving on that issue. Now, in terms of something that is coming up right now a lot for employers, let's talk about COVID-19 and vaccine mandates. It seems like the administration really wants to use employment relationships as the means to get more people vaccinated.
Well, clearly, if you listen to the president on Thursday, September 9th, he laid it out very clearly that he is going to expect employers on all fronts to try and lead the effort in making sure that the country is vaccinated. The president issued 2 executive orders, and we know we will also be getting some OSHA emergency standards to come shortly. The first executive order was that all federal government employees will be vaccinated. Secondly, federal government contractors or subcontractors, which oftentimes manufacturers can be. There are many manufacturers that manufacture equipment, different things under federal government contracts. Those contracts going forward, not the contracts that have already been let, but contracts that get issued after, I believe it was October 15th of this year, they will all have to have a clause that which the winning bidder and all of their subcontractors have to have in place rules and provisions for their employees to be vaccinated. It will be mandatory, presuming the only exceptions being perhaps religious accommodations for sincerely held religious beliefs or a disability accommodation. And if those 2 things are there, then the employer will have to work with the employees through the reasonable accommodation process to see if there is an accommodation for the person to not be vaccinated. Next, what the president did is he said that any employer, private employer who has 100 or more employees will have to, under an OSHA emergency standard, will have to make sure that their employees are either vaccinated, or if they, for some reason, have an accommodation reason for not being vaccinated, be tested on a weekly basis. And there are all sorts of questions as to that executive order. We haven't seen the specific language yet. As soon as it comes out, we'll, of course, evaluate it and get information out to people. But there's just so many unknowns about that rule and how it will apply, what exceptions there may be. What if your employees are remote working and they're not in the office? Are they still going to have to be vaccinated and or tested every week? Who will have to pay for those tests? That's going to depend somewhat on the rule, I think, but also that can be a state-to-state issue, depending upon how your state treats certain tests. Virginia has said that testing, these COVID-19 tests are medical tests, and there is a Virginia statute that if an employer makes an employee take a medical test, the employer has to pay for it. So we'll have to see how that plays out. The other thing we've had, if you are in Virginia, and there are many other states that are starting to follow that lead, last week, the Virginia Department of Labor and Industry issued its latest emergency standard or permanent standard now that they want to use for controlling COVID-19. Many employers, especially manufacturers, were dealing with that regulation last year into May of this year. But as of September 8th, there isn't a new emergency standard that employers need to familiarize themselves with and comply.
So speaking of where we think that the administration is going, another fast-moving area is the issue of non-competes. It looks like their popularity may be coming to an end to a large extent. Could you sort of talk about the national push to restrict them?
Well, President Biden back in July issued an executive order where he encouraged the Federal Trade Commission to start looking at covenants not to compete and whether they are hampering interstate commerce. And the president feels that the excessive use of these covenants not to compete, in his eyes, have created a situation where during COVID-19, it's driving up unemployment rates because people are, being laid off in one place but can't go work in another because of a covenant not to compete. And just as a general economic rule, it's covenants not to compete are often disfavored and they're highly technical, and you have to make sure that they're drafted narrowly. And so the president is looking at that issue. We've seen many states do that too. I mean, this is a kind of a wellspring issue across the country right now, and many states are adopting their own statutes, either prohibiting covenants not to compete or not permitting covenants not to compete with what are referred to as low wage earners. Oftentimes in manufacturing, if your employees are not making a certain amount of money, you could fall under those statutes, and a covenant not to compete would not be enforceable with an employee if they weren't making a certain wage rate. In Virginia, that a low wage earner is someone right now who's making, it's tied to the consumer price index and everything like that. But employees that are making, less than $60,000 a year are low wage earners. And therefore in Virginia, you cannot have a covenant not to compete with those individuals. Other states, the District of Columbia has banned non-competes. It also has said that you have to allow employees to moonlight. So even if it's not a competitive activity, some employers say, if you want to work for me, I'm your only job. DC has said, nope, if employees want to moonlight, they're allowed to do so.
Yeah, that's definitely a huge update. Well, thanks, David. That's going to actually wrap up our discussion today. So to sum it up for our viewers, I just have some quick takeaways. Firstly, classify workers correctly. It's cheaper to pay employees their full wages than to have to do it on the back end along with attorney's fees. Secondly, look carefully at your non-compete agreements to make sure that they are in compliance with the law. Also, marijuana legalization. It is a nuanced issue. You don't want to get sued by an employee, but you also don't want to lose a government contract. So just make sure that you are being vigilant. Lastly, vaccine mandates are here and they are being instituted oftentimes through employment relationships. So just be ready to deal with that issue as well. If you have any questions, please reach out to David or to me. Please also be sure to visit our labor, employment, and immigration practice area webpage and our manufacturing industry webpage on our website at www.williamsmullen.com. There, you'll find a document that summarizes today's video and other resources. Thanks for your time and have a great day.
Thanks, everybody.